Welcome everybody to our Start Smart legal series, which is startup law. We've had a series of topics. All but one of these have been taped and will be available in the YouTube under CMU's workshop archives in the Schwartz Center. Stephanie, do you know, or Tiffany, do you know where yours are or will be? Or do you just use our link?
Yeah, so we'll also post it to the Big Idea Center website. There'll be a programs tab at the top. You'll just click that and then there'll be a Start Smart page and it'll be there as well.
Okay, so again, welcome. My name is Kit Needham. I'm the Assistant Dean for Entrepreneurship Initiatives at CMU, and I am the Director for Project Olympus, which is we run the Startup Incubator programs at CMU. And my colleague is Stephanie.
Yes, Stephanie Dango. I'm a professor of practice at the University of Pittsburgh School of Law, and been partnering with Kit and now with the Babs and the Big Idea Center at Pitt to present these workshops with our friends from K&L Gates. I think we've been doing it for at least 10 years. And I've known David and Mike for much longer than that.
Yeah, so she used to be a lawyer at K&L Gates, so it's in there too. So, well, I'd like to introduce David Lehman, who is our partner in producing these series. He's one of the finest startup lawyers in town, and his colleague, Mike, who has been with, you've done this, what, how many times? Mike, 5, 6, I don't know.
It's been a while. It's been a long time.
Mike Pavlik, who is all about our what we call hiring and firing, and keeping you on the legal side of what you do with these summer interns, et cetera. So I'll turn it over. I don't know who's going to lead.
So let me get started, and then Michael take over. How's that?
Okay.
So let me see if well, hello folks. I'm David Lehman, and my partner, as Kit said, my partner is Mike Pavlik, who's here as well. And we're going to talk about employment matters, particularly as it relates to startup companies. And so Mike's going to talk about the classification of workers and that significance. Then I'll spend a little bit of time talking about employment agreements and the covenants, employment contracts, covenants, such as non-competes and those kinds of things. Then we'll talk a little bit about employee equity. What kind of equity should you give people? How much? What's the form of that? What's the benefit of those kinds of equity arrangements? And then, that's it. It says here, and I want to remind you, it talks about questions and answers, but don't wait for that. Interrupt us, stop us, ask us along the way. This will be much more interesting if you ask questions along the way. Okay. And with that, I'll turn it over to Mike.
Thanks, David. If you could, yep, perfect. So, I mean, imagine that you have a farm and you have 6 silos on the farm, each filled with certain kinds of grain, and you're trying to figure out what grain you need to do whatever you need to do. That's kind of what we're going to talk about in my part of the presentation. Those silos that I'm talking about are actually workers, and you're going to want to identify what types of workers or what classifications of workers might be the best fit for your business. There are, and let's sort of start off with the idea that there are probably about 6 basic categories of workers, and we'll talk about all of these today. One type of worker is an employee, and then there are independent contractors, interns, trainees, volunteers, and apprentices. And depending upon what you want that worker to do and where you want that worker to do it and how you want that worker to do it, you're going to want to pick one of these categories. And of course, the game is that you want to pick the right one, because if you pick the wrong one, you could be in violation of law, and there could be all sorts of penalties and other bad things that could happen. So David, if you could switch the slide. So the main classification, sort of the default here. So in other words, if you were trying to figure out how to classify a worker, you're going to start off with sort of the idea that this worker is going to be an employee. All right. But being an employee might not be the most advantageous for you. It may not even be the most advantageous for the worker. So the question is, why might it not be advantageous for you? Why does it matter how you classify someone? Work is work. So why would it matter that I call someone an employee and someone an independent contractor and someone an intern? The basic reason for that is that there are many laws that apply to employees, but not other types of workers. So for example, tax laws. With respect to an employee, you're going to issue that employee a W-2, and you're going to withhold from their paychecks. You're going to have to pay your portion of FICA and FUTA tax, which is roughly 3.65%. The employee is going to have that portion of tax withheld. You're going to have a withholding obligation to withhold other taxes from that employee's salary. And at the end of the year, you're going to give that employee a W-2 to reflect that you did all that correctly, and so forth. Now, on the other hand, if the worker is an independent contractor or something else, maybe you might issue that worker a 1099. And with respect to a 1099, you don't have to withhold. There is no FICA and FUTA tax. So all you're doing is paying the worker and providing them a piece of paper at the end of the year or at the beginning of the next year, evidencing the fact that they were paid certain amounts. So, there's an advantage to some extent to being paid or being able to pay your workers on a 1099 basis rather than a W-2 basis. But again, one of the things I want you to keep in mind as we sort of work through all these issues is that the presumption is that the worker is an employee, okay? So you start off, I think, with that basic proposition. This person is probably an employee, and therefore I need to W-2 them. I need to withhold taxes and pay my portion of those taxes. Another issue where there's a distinction between employees and other types of workers is wage and hour. Wage and hour is what you pay the folks, right? And the basic construct in the United States is that you have to pay overtime to workers. Now, there are certain exemptions that might apply depending upon the worker's duties, depending upon what their salary is, okay? And depending upon whether you give them a guaranteed amount. These are all tests which determine whether someone is what we call an exempt worker and therefore not entitled to overtime, and for that matter, not entitled to a minimum wage. Although as a practical matter, the minimum salary is going to cover the minimum wage. If you are an independent contractor or some other type of worker, you don't have these overtime obligations or you don't have these overtime rights, okay? So a company that has independent contractors doesn't need to pay a minimum wage, doesn't need to pay overtime, and doesn't need to satisfy the various tests to avoid paying those things. They get to classify, or they get to pay, I should say, the worker as they see fit. Another area where it becomes an issue is benefits, all right? Employees, to the extent that you provide benefits, must be provided those benefits in most instances. Otherwise, it's unlawful discrimination under ERISA. On the other hand, independent contractors and other types of employees are typically not classified as employees entitled to benefits, and you don't need to pay benefits. Employment discrimination. In many instances, workers who are not classified as employees are not subject to employment discrimination laws, do not benefit from employment discrimination laws, which means a company has more of an ability to fire someone. Now, I'm not advocating that anybody would want to fire someone for illegal reasons, but those laws typically don't apply to independent contractors. They do apply to employees. And then labor laws. If you want to avoid unions, have a bunch of independent contractors, because independent contractors can't organize. They aren't subject to the National Labor Relations Act, and therefore they can't form a union, whereas employees can form a union. So these are just some of the instances where this dichotomy between employee and sort of everybody else comes into play. And again, I want to stress the emphasis or the presumption is that the worker is an employee, but to the extent that you can possibly put that employee into another silo, right? All right, then you might have a situation where you don't have to comply with all of these laws that potentially are applicable to employees, but not to other classifications of workers. The last bullet point on this slide, I just want to briefly mention, things change, okay? Your business changes, your needs change, what workers do change. And as a result, you may identify a worker as an employee initially, and then realize that, you know what, this looks a lot more like an independent contractor relationship. Or conversely, you may identify someone as an independent contractor and then say, you know, I'm starting to exercise a lot more control over the work this person does. Now maybe I have an employee situation. So always keep that in mind. And David has read my mind, so we are on to the next slide. So the game here to some extent is to classify workers correctly. Are they employees or are they something else? The game is not necessarily an easy game, okay? Misclassification occurs on a fairly regular basis. There was a New York study several years ago that 10% of all private sector workers are misclassified. So it's not uncommon to have seen misclassified workers. As a result, you're seeing increased government attention towards this. States have set up task forces, attorney general's offices are, I don't say prosecuting, but pursuing investigations of companies that make heavy use of independent contractors. I know I'm involved in one of those right now for a client of mine in another state. So these things happen, okay? The government is paying attention to this. You know, the new economy, and this slide is a little bit old and I have the word new, and you might even want to put gig there. The gig economy means that that employers are out there trying to cut costs to some extent. And the states, well, they lose revenue when a worker is classified as an independent contractor as opposed to an employee. And as a result, the states become more aggressive in taking a look at these issues and trying to classify and trying to see if they can reclassify workers as employees rather than independent contractors. And we're also starting to see some legislative impact, okay? I mentioned two statutes here. I'll take the second one first, which is the PRO Act. The PRO Act isn't actually a law yet. It is a piece of legislation that is currently, it got through the House, the federal House, so the House of Representatives. It has not passed the Senate, and there is, unless the filibuster goes away, there is very little likelihood that the PRO Act will pass. What is the PRO Act? Well, imagine if you put 20 union people in a room and gave them a piece of paper and a pen and said, please write down your wish list. Please write down all the things you think would make unions stronger, okay? And then give me that piece of paper back. And so the person who collected those pieces of paper then basically took all those ideas, put them in a piece of legislation, and said, okay, here's the PRO Act. PRO Act stands for Protecting the Right to Organize. So now we have this PRO Act, which is an incredibly pro-union piece of legislation out there. And you're asking me, why am I talking about the PRO Act? And especially when there's probably very little chance that it's going to actually see the light of day. Well, it's not so much the PRO Act itself, but the ideas that are embodied in the PRO Act. And the PRO Act takes a very strong position on independent contractors and classification issues and greatly limits companies' abilities to classify workers as independent contractors. To a large extent, it borrows from the second piece of legislation there mentioned, which is California's AB 5. Okay, and AB 5, also called the ABC test, is a statute which has greatly narrowed the ability of companies to classify their workers as independent contractors. We'll talk about AB 5 and the ABC test in a second, but those are some examples of legislation that's out there that's going to make this game that I'm talking about harder to get right, or at least harder to get the result that you might want. So I'm just going to talk very briefly. You know, we're talking about independent contractors and employees, and some might think that's a relatively easy line to draw, and it's not, unfortunately, an easy line to draw. So I always point to the Fair Labor Standards Act, and this is the wage and hour law that I referenced earlier that talks about overtime and minimum wage. And the Fair Labor Standards Act only applies to employees, right? So what's an employee? Well, an employee is any individual employed by an employer. So that's not very helpful. An employer is any person acting directly or indirectly in the interest of an employee in relationship to an employee. That's not terribly helpful. And to employ means to suffer or permit to work, which again is not very helpful. So the statutes aren't very good at defining what's an employee and what's a something else, a worker or something else. And so we end up having to sort of read the tea leaves to figure out whether someone is should be or could be classified as something other than employee. This last bullet point about the FLSA having the broadest definition ever included in any one act, well, that sounds impressive, but what it means for our purposes, I think, is it means that, again, there's the presumption that employment is the model, not independent contractor, not intern, not trainee, not apprentice, not volunteer. You sort of start off with the idea that the worker is probably an employee, and then you sort of have to work away from that concept in order to determine whether, in fact, you can treat the individual as something other than an employee. So we could switch slides. So the employee versus independent contractor test, or the employee versus someone else test, it's a bit of a mess from the standpoint there are all kinds of different tests out there. There are tests which focus on right to control. There are tests which focus on economic reality. There are tests which are sort of a hybrid of those various concepts. And as a result, if you read the case law, okay, the lines often blur between the tests. And the courts may purport to apply one test, but they're applying another test. And so it all gets to be, again, this is a little bit of a theme, a big mess, right? So let's flip the slide. And the next slide is one court's effort to try to address the mess and to come up with sort of a unified single test. I don't want to suggest that this test has broad applicability. What I like about this test, though, is that it identifies the factors that seem to come up most often as to whether someone is an employee or whether someone might be classified as an independent contractor or something that is not employee-like. So there are 12 factors identified. I'm not sure I want to go through all those factors, but I do want to now talk very briefly about ABC and the California ABC test. By the way, ABC has no significance whatsoever. I always thought ABC was an acronym for something, and it's not. Basically, there's three parts to the test, A, B, and C. So Californians, in their infinite wisdom, decided to call it the ABC test. So that's what we have. We have this ABC test. And the ABC test, the first part of the test, A, is whether employees are, or whether the workers are free from control by the hiring entity. If they're free from control, they might be an independent contractor, okay? What's interesting, if you take a look at those factors that are listed here, a lot of these factors go towards control. So the source of instrumentalities and tools, who provides the tools to do the work, the location of the work, are you told where to work, duration of the relationship, how long is the relationship, can the hiring party assign additional projects, the hiring parties, or the hired parties rather, discretion over when and how long to work. The method of payment is sort of a weird factor. It doesn't really fit into the ABC test, but as you can see, there are a number of things here which talk about control. The ABC test, and I'm using it sort of as an extreme, and again, it doesn't go, most jurisdictions don't go as far as the ABC test, but the ABC test doesn't just focus on actual control, but it also focuses on the right to control. So even if the company, even if your company doesn't actually exercise certain indicia of control, if it purports to retain the right to exercise those indicia of control, it still looks and talks a lot like an employee relationship and not an independent contractor relationship. So the first part of the ABC test, the A part, is being free from control by the hiring entity. The second part is that the work is is outside the usual scope of what the hiring entity's business usually does. Okay, so the classic example, and if you read the California Department of Labor, and that's not what it's called, I forget what they call their Department of Labor, but if you read their website, they talk about plumbers, they talk about electricians, and that's kind of what we're talking about here. That's kind of what they're saying are sort of the classic independent contractors. So if you have a company and you need someone to come in and fix the lights, well, that would be an independent contractor in all likelihood, right? Unless you had an electrician on staff, okay? And then maybe it's not an independent contractor because that's part of your normal work. So that's the second part of the test. The third part of the test is whether the worker is customarily engaged or independently established in the type of business or the type of occupation of the work being performed, okay? So in other words, they are incorporated, okay? Or they have some sort of license, or they have some sort of certification with respect to the type of work they're doing, okay? So again, we sort of get into electricians and plumbers, okay? If you're a bookkeeper, though, maybe not so much, okay? So that's the ABC test. And just, I bring it up because it's hard. It's a hard test to meet. The ABC test really reflects itself in these 12 factors because, you know, we talked about the control factors. We talked about the work is outside the scope of the hiring entity's business. Well, you know, that's the, you know, which one of this is, one of these is the work is part of the regular business of the hiring party. That's the same test, right? And the last part, or, you know, they're customarily engaged. That's the hiring party is a business and the hiring party can work elsewhere. Okay. So the ABC test is sort of incorporated into these factors. The draconian thing about the ABC test is all three factors need to be met, whereas these factors are sort of a balancing test, and some may go your way and some may not. And you sort of get to weigh and balance and decide which way you want to go and hope you're right. Whereas the ABC test says if you don't meet A, you're done. You have to classify the worker as an employee. Same for B, same for C. Okay. So that's our independent contractor employee classification. Those are some of the issues that come up in that context. If we could flip the slide. I do want to mention very briefly joint employment. Okay. It's a concept that's sort of a little bit outside of this. But just because you are not the employee, just because you're borrowing workers from someone else, okay? So for example, you get them from a staffing agency or they are seconded to you from someone else, that doesn't mean that you might not be an employer, okay? Because depending upon what the joint employment test is and whether it's satisfied, and the joint employment test talks to things like who hires and fires, who determines the method of payment and the amount of payment, who maintains employment records, and you know who supervises the work. Okay, and if those tests or if those factors indicate that that's you, even though it's not your W-2 worker, even though it's someone else's W-2 worker, you could be viewed as a joint employer in that context. And all these laws that we're talking about may apply to you, even though again there's another employer who says yes, I'm the employer, but you may be a second employer and be equally liable. All right. So just be aware that just because you get someone through an employment agency or you second a worker through another source, that doesn't necessarily create a situation where you're not going to be the employer. We can flip the slide. And so, you know, as I've said, the threshold inquiry is whether the worker is an employee. Okay. If the worker is a contractor, the arrangement is largely contractual. Okay. You have a contractual arrangement. You decide what the terms of that contract are. You and the contractor agree, and you follow your contract. All right. But if we get into the situation where you have an employee, then you have a lot of different laws that you need to deal with. Okay. And we sort of get into these other categories of workers. Okay. So now we have an employee, but can I push this employee into one of these other silos? Okay. And that would reduce my burden with respect to that worker. So if we could flip the slide. So one of those silos is unpaid interns and unpaid training and unpaid trainees. Okay. And those are permissible classifications. You can classify workers as interns or trainees, as the case may be. There are 6 criteria that must be met per the Department of Labor in order for you to classify someone as unpaid interns and trainees. Those are not easy to meet, okay? And I don't want to suggest you need to meet all of them, okay? Because the courts generally have said, yes, those are 6 criteria, but maybe you only need to meet 4 out of the 6, or maybe you only need to meet 5 out of the 6. But you got to be close, right? Even on the ones that you're not hitting, okay? So what are those criteria? Well, the activities have to be similar to training in an educational setting. So we had at the beginning of our discussion, someone is looking for a mechanical engineering intern, okay? So the question is, can I provide a setting that's similar to an educational setting? Now that may include the operation of employer facilities, but the idea is that the person is learning, they're being educated, they're receiving some sort of intellectual or academic or educational benefit, okay, from their work. The experience is primarily for the benefit of the intern, all right? If you're having the mechanical engineering intern do all the work that a regular mechanical engineer would do, and you benefit from that, I'm not sure it sounds a whole lot like the experience for the benefit of the intern. It looks like it might be for your benefit, okay? So that's another factor. The intern trainee does not displace regular employees, all right? So in other words, if you have a mechanical engineer who resigns and you say, "Hey, I'll replace him with an intern," well, that's probably not going to meet this criteria. The intern trainee has to work under close supervision. They can't work under, I should say that. They have to work under close supervision. You can't sort of let them go and say, "Here, do your job." The whole idea is that they're being educated, they're being trained, they're being developed in one way, shape, or form. The employer derives no immediate advantage from the work of the trainee. And occasionally operations may be impeded because this person is going to be slower. But again, there's an educational component to this, and you're teaching this person how to do this. So, you're going to spend an extra hour on this project because you're working with the employee or the intern and trainee. The intern trainee is not necessarily entitled to a job at the conclusion of the internship training, okay? And there is an understanding, in order not to pay the individual, that the position is unpaid, okay? Let me just say this. If you pay an intern or a trainee, you're basically treating them as an employee, and you're going to need to make sure that the pay is consistent with the requirements of the law. If we could flip the slide. So let's talk about volunteers. And I'm not going to spend
Mike,
yep.
This is Kit. I'm going to just interrupt. If you want to, David, can you go back to that prior slide? So this is the one that's going to cause, well, I would guess like 85%, 90% of the people are on this, attending this right now, is because they want to get, quote unquote, interns for the summer.
Yep.
And that they can pay maybe something, but other times there are interns who are required to have an internship during for part of their curriculum, for which it is not required, according to the CMU curriculum, that it be a paid internship.
Right.
So I'm sort of, if you, and the other piece of this is employer derives no immediate advantage from work.
Right.
So everybody's calling them interns. You're saying that they've got to be an employee, but they can be a 1099 employee. But when you said you got to pay them, can you talk a little bit more about what is there any kind of a range or how to work that?
No. So let me be clear. You don't have to pay them. As a matter of fact, the whole idea behind interns and trainees is that you don't pay them. Okay. What my point is that if you're going to pay them, you should pay them a minimum wage. So that's, I don't know if that directly addresses your question, but that's what I was trying to get across.
Well, but if you're actually getting a benefit,
so that's one of the factors, Kit. All right. And so it's not the only factor. And it's one of the, listen, I mean, this is one of the more difficult factors, because I can make the argument that almost every single internship arrangement in one way, shape, or form benefits the entity that utilizes the intern, right? There's going to be a benefit. I think the idea really, and I'm going to put this into a nutshell here, the idea is that this intern is basically not functioning as a fully developed, fully fledged employee, right, who is doing all the work that you would expect of hiring someone off the street. Rather, the person is sort of supplementing, the existing work. Okay.
Okay.
And even if it's one person, right, and you're the owner and the operator of this business, and you decide that you would like to have an intern, well, if you're doing a lot of the work, right, then, and you would have done the work anyway, then you could bring in someone, I would think, okay, depending upon how you structure it, and have them do meaningful work that's going to benefit you and maybe even reduce your hours, right, and reduce the time you're spending on things, or certainly help you move the ball forward. And I think you'd still be okay under this test. This test has been criticized a great bit because it's not terribly clear. It's not terribly concise. The Department of Labor's position has shifted on these various things at various points in time. And so as a result, there seems to be a genuine issue as to what exactly an unpaid intern or what exactly a trainee is. And the important thing, Kit, is that you sort of look at these 6 factors and try to put as many in the intern trainee category as you possibly can, and then say, okay, that looks good. Can you provide some sort of educational credit, for example? Can you provide some sort of you get 3 credits for doing this? Not necessary, but that helps, right? Can you show that there's an educational component to this? Can you show that the person's being supervised and that the person is being, instructed and directed and educated? And then you start looking more and more like this is in fact an internship rather than just you getting a cheap worker.
Okay, so for example, one of the things that we always tell students who want to work for a startup over the summer in particular is one of the benefits is you're kind of at the table. You get to learn a lot about startup stuff. You're not just stuck in a desk someplace and just told to code away, that you get insight into the marketing, the financial, the customer service, the research. Okay. So that could be part training and part
training and part education. And listen, there's nothing wrong with hands-on education, right? Hands-on work. But again, it needs to be. I'm simplifying this perhaps a bit, but again, you're not just looking at the internship as a source of cheap labor in lieu of hiring someone who from the street. Instead, you're saying that there's an educational component to it. There is a training component to it. There is a benefit to the intern to it. And yes, you may incidentally benefit. I get that. Believe me, very few companies are going to hire interns and not expect to have some benefit, right? Even if the benefit, hey, this is a future pool of workers for us. But the idea is that you're going to get something out of them.
Yeah. Okay. Well, I was just trying to give a little hint to some of the folks too about some of an easy to do training component, which is extremely valuable, by the way.
Yep.
Absolutely. Does Jason have a hand up? Is that what I see?
I can't see.
I just had a quick question on the final bullet point. So I saw that this was, I think you're going to hit upon this later in your outline, but how would equity tie into compensation for the intern, if equity is even a suggested thing? And if you're going to hit upon this later in the presentation, then don't mind me, and I guess we can get to that later.
Well, so that's going to be really David's area, but this is a great opportunity for me to raise something that I wanted to raise, and I just couldn't figure out where to raise it. I talked earlier about the idea that if you have these employees, they need to be paid sort of minimum amounts, minimum wage, overtime potentially if they don't meet certain tests, a minimum salary, blah, 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 right? And that can be daunting and that can be intimidating, right? If they're actually employees. If they are owners though, okay, then all of those tests go away. And you can sort of pay them what you want. It's a nice little quirk, so to speak, in the wage and hour laws. It's the bona fide owner exemption. It's part of the executive exemption. Now, let me point out, and I want to be I want to be clear that it's limited from the standpoint that the person has to own a minimum of 20% of the business. Okay, and I suspect that you're not going to give an intern a 20% ownership interest in your business. But just something to think about. But Jason, with respect to the art and the science of equity, I'm gonna let the expert speak on that later.
Okay, thanks.
David, if we could.
Also,
Yep.
I also have a quick related question.
Sure.
If that's okay. I'm just curious if it's possible to quantify how many internships are paid versus unpaid. Is it like 50-50 or 20-80? And I'm not sure if this is a question for Mike or Kit, because they may have like different people that they see, but I would still love to see hear what you
Yeah,
think.
so I'm going to punt on that because I, Martina, have no data on that. So I don't know if Kit has any data on that.
I don't want to comment because I don't think it's legal. So,
Okay. That's okay. Thank you.
All right. So
So
if we can.
Yeah.
I will
Yeah,
just
we
make
do-
the comment that this seminar, when we first did it, was an eye opener for me and a number of people in the room, because we were operating under certain principles. And I will just tell you, and this is far enough back that we probably won't get in trouble for it. But when I asked one of my startups what he has been paying his interns, he said, I never pay interns. But he was getting considerable value. So and I said, well, we have to rethink how we do this now. So that's all right.
Yeah, and let me just point out again, unpaid internships are fine. They just have to fit within the criteria, right? Okay. And my point about if you're going to pay the person, then you should probably pay them, consistent with the law. Is just reflective of the fact that the factors are going to mitigate perhaps against a finding that person is in fact a true intern.
So most of the startups don't have money. So that is part of the problem.
Yep.
And there are a number of people that actually want to work there to get the experience. They want some credentials on their resume. So that's a benefit to them. But so it's a little bit of that catch-22 about the need, and both are willing. But I think what triggered this was the runway of visibility that how they were abusing their interns, where they were literally using them in lieu of employees.
Right.
So, but these are startups that haven't necessarily even formed. They're not a company even. You might call it a project. So I don't know how you handle something like that.
Well, and Kit, from the past presentations, we've talked about the idea of, instead of classifying these individuals as interns or trainees, right, which is a form of employee, instead you classify them as independent contractors, and then you can pay them what you want, right? Because there are no minimum requirements with respect to independent contractors. And so, it could be a very nominal payment. It could be payment in kind. It could be, some form of equity. It could be, a few dollars here, a few dollars there. It could be a free lunch, right? And so, that's the other option. But again, you still have to meet the test for independent contractor under that scenario. I keep going back to the idea that the default position, per the law and as a practical matter, is that the person's an employee, and you have to go and make a case internally, not externally, but internally, for why you want to treat that person as someone other than an employee.
Yeah, thank you. Yeah, it just makes me think that this distinguish or the category may also depend on what's needed for university. Because in the past, I was supervising some of the interns we had on the team, and they were from Duquesne University, and it's basically part of their curricula that they have to have internship, and it has to be certain amount of hours for a certain amount of weeks. And
Right.
If they study a certain field, let's say healthcare, is a requirement that certain amount of hours are within the field of study. So that may also be a factor to determine where to put them.
Absolutely, because they're getting credit for that, or if they're not getting credit, they're getting some sort of they're meeting some sort of requirement for their graduation or for their major. So, I mean, that talks a lot more to me like an internship.
Yeah,
So,
definitely. Thank you.
I'm running a little bit short on time. I'm not going to spend a lot of time on volunteers. Let me just tell you that unless you are a for-profit, a not-for-profit company, you do not want to use volunteers. Okay. That basically only not-for-profits can use volunteers. So David, we could flip the slide. And so again, these factors really relate more to nonprofits. These factors aren't for-profits. So these are the basic volunteer considerations. You know, was there any expectation of compensation? Whose benefits? Is it integral to the business? Coercion, pressure, time of activity, and so forth. But the bottom line, again, is that if you are a for-profit company, you can't use volunteers. If we want to flip the slide one more time. Now, I just said, if you're a for-profit, you can't use volunteers. And that might be too sweeping of a statement, because you can use volunteers, just not to do your work. You can use volunteers, for example, if you're UPMC and you're sponsoring a golf tournament, and UPMC is probably a bad example because it's a not-for-profit. But if you're Alcoa and you're sponsoring a golf tournament, and you want to have a welcome tent and you need people to staff the welcome tent, you can ask your employees if they would be willing to volunteer for that. And assuming it's not coercive, and assuming that it's outside normal working hours, assuming there's no negative ramifications for not doing so, assuming there's no expectation of compensation, assuming there's some sort of charitable or civic activity behind it, then you might be able to use volunteers. But again, that's such a limited subset of the right to use volunteers that it's just, I mean, I can't stress enough, if you're for profit, don't use volunteers. It just doesn't work. And last and maybe least, I want to touch briefly on apprentices. There are about 950 occupations recognized as apprenticeable. And if you have apprentices, it allows you to pay them sub-minimum wages. It allows you to pay them sub-minimum overtime rates or no overtime rates at all. It gives you the opportunity to get funding to pay some of these folks. There's some opportunity for unpaid training. Okay. So, you know, there is the possibility of using apprenticeship programs. The big drawback to apprenticeship programs is simply that they're limited. It's typically the trades. And when I say the trades, I'm talking about, you go to a construction project and you see people working on a construction project, those people are in the trades, right? So there's sheet workers, and there's electricians, and there's plumbers, and there's pipe fitters, and painters, and so forth. Those are considered to be the trades, and that's typically where you see apprenticeship programs. But depending upon the type of work you're doing and how you're doing it, that is an option. So David, if we could flip the slide. And that's what I have. So at this point in time, I'm going to flip it over to David, and he can talk about employment agreements.
Unless folks have questions about your part.
Yep, absolutely.
So, of course, they can always recall the witness.
Correct.
So let me talk for a moment about employment agreements for startups. And the first point is that it is helpful to have written agreements, and it's a good thing to have. And when I talk about, they can either be full-blown employment agreements, or they can be letter agreements or offer letters or those kinds of things, but something in writing. And the reason, there's a couple of reasons. One is that oral agreements are enforceable, at least some, and so you don't want some argument later about what it is. For startup companies, misunderstandings, litigation is a bad thing. You can't afford litigation. You can't afford misunderstandings. You can't afford, for example, somebody claiming, which I have one going on right now. As a matter of fact, there was a misunderstanding with a former CEO as to how much equity he deserves. So he wrote a letter saying, I'm entitled to 15% of the company. And there they are, they got that letter and they have that allegation. And now it's a he said, she said. And the problem is that now, how do you go raise capital if somebody claims to have 15% of the company? And so you got to go resolve it. If it were in writing and had they done it properly, that wouldn't happen and we wouldn't have this problem. So we're going to work on it. But so part of the reason is to have it in writing and have a clear understanding. And the other is to have enforceable covenants, which we'll talk about in a moment. So having written, and again, it doesn't have to be formal employment agreements, and certainly they're at will. I mean, you can terminate, be clear about what the arrangements are, and that's cool. This one, this talks about review it carefully. You know, this is more of a general comment, but about employment agreements in particular, which is read them carefully. I mean, there's a tendency, particularly in today's world of DocuSign, where you get a contract, you sign it, and it's very easy because you just sign here. But contracts do have meanings; they have real implications, they have real world things, and so people ought to understand what it's about. Some important terms in the contracts. Obviously, you want to make sure that it's clear what the person's going to do, how much you're going to pay them, base, bonus, how it's calculated, what expenses you're going to pay. I mean, as a business person starting a company, it's important to pay attention to the business terms. Sometimes it turns out lawyers sometimes screw up if they're drafting it, or you make a mistake in filling it up. It's really important to be careful. There's nothing worse than looking back at a contract and realizing afterwards that you didn't put in the business terms right. So pay attention to it. Be careful of the benefits. What benefits are they going to get? And if they're not getting any, be clear that they're not going to get some. So there's no question about it. Term, we talked about at will. I mean, I mentioned it's important to put in the agreement that they're at will, that people can be terminated with or without cause. They can resign with or without cause. And so be clear about that. So there's no misunderstanding, because sometimes if you may have a policy, create a policy, it's very clear to have it just in place. Sometimes people get severance, and some people expect severance. And so it's good to be clear as to what that is, and have a clear understanding with the person. I will tell you, don't overdo it with the severance. People sometimes like to be generous on this issue. And that can be a bit of an issue when people are coming in to invest in the company, or otherwise they see very large severance packages that are due, particularly to the C-level employees. So that's a bit of an issue. And I mentioned here, just for fun, the accrued compensation commissions, because commission structures can be just a little tricky. And so you want to, when you're crafting, or particularly for salespeople, you're paying them commissions, just be careful about how it's based, what happens when they leave, is there a tail on the commission, et cetera. Just that's important.
Hey, David.
So, yep.
David, this is Don Morrison.
I recognize that voice. Yes.
Just curious about the relationship between severance agreements and non-compete agreements. My experience suggests there's some linkage in some cases, especially for senior level. You know, if you have a 2-year non-compete, there might be a 1 or 2 year severance tied to that. In other words, you're depriving someone of their ability to make an earning or a living in the category. Can you speak to that?
So
can I just jump in? Can you also comment on not only non-compete, but also non-disclosure when you talk about the group? Sure.
Well, actually, I'm going to talk about all of them, but let me. So the answer is yes. We want all of those things in the agreement, and so let me speak to the point about the tie between severance and the non-compete period, because you do want to draw the larger picture. When you hire employees, it is important to have, or at least think about having non-compete obligations by them. And in order to, and we'll talk about, let me just go to for 1 second, just so I'll use this as the, and when you do it, it's important to make sure that you have consideration. You have to give people something in exchange for that non-compete. And actually it turns out that simply giving people a job qualifies. Now that means, by the way, that you have to give them the job when they sign up for the non-compete. So as an example, if they've already employed and then you're not giving them a job and you want them to sign a non-compete, you got to give them something different in addition to for that. So there needs to be consideration, something in exchange for it. The courts will only enforce non-competes for reasonable periods of time. And to Don's point, usually sometimes, and Mike can weigh in here, the longest I see on the employment context is maybe 1.5 years, 2 years. That's the longest I see. People want to sometimes do longer than that, but that seems like the longest that you can be, seems to be reasonable. I understand, of course, non-competes aren't enforceable everywhere. Different states have different rules, but we'll talk about that. California, for example, doesn't generally enforce non-competes. It needs to have a substantive scope. You can't just say we're not going to compete. You need to say, be very specific in what they're not allowed to do, because the idea is that they're not supposed to be competing in a way that takes away, I'll call it the goodwill or the business. So it's got to be narrow in scope, geographic scope, which is kind of strange in today's world. It just has to be reasonable. To your question, Don, I sometimes see it, but it's not required that the severance be tied to the non-compete. I mean, it is a better argument to get somebody to sign a non-compete that says, look, if we fire you, we're going to pay you severance for there's a 18-month non-compete, and you're going to get severance for 18 months. Therefore, it's a reasonable thing to sign. So that is a good business argument in favor of doing it. It helps. But it's not required. Those two don't.
So let me
have
just
to
add
match.
that real quickly, David. I mean, that's exactly right. I mean, you don't need severance to enforce a non-compete.
Right.
On the other hand, if you provide severance, it's going to make the likelihood that non-compete is going to be enforceable all that much more high, right? I mean, it's going to be much more enforceable. So if you have, I mean, so to use your example, I mean, I agree, 1 year, 18 months, maybe 2 years is sort of the outer limit. But if you want to sort of buy some extra years with some severance, that might be a viable strategy. You don't need to buy that first year or 1.5 years, but maybe you buy an additional 6 months, or maybe you buy an additional year by providing some sort of severance. I mean, that's one way of looking at it. The other way of looking at it is simply, hey, you know what? This person is not injured by this agreement because they're getting paid anyway.
My experience is one without the other usually is not a good proposition. Whether you're the employer or the employee, if you're asking for a non-compete and there's no severance, that's kind of a unfair proposition, and so is severance without a non-compete. So
yeah, my experience is similar, but my experience is also that there's rarely except on the executive level, they rarely match, which is companies often and most typically provide relatively modest severance of call it weeks, and a longer non-compete, maybe a year. So my experience is certainly on the CEO level, or the C level, that you're absolutely right. Lower level employees, not so much. That's my experience anyway. But again, it goes to the importance of having it crafted correctly. Mike, you agree with that?
Yeah, no, I agree. I mean, again, these agreements are enforceable without severance. You tack on a severance provision, and it makes them more enforceable. That's the simplest way of looking at it.
Yeah. Another piece of paper we want employees to sign is a confidentiality agreement. I mean, as you're looking at the sort of the raft of things we want them to sign, and you asked about this, you certainly want them to sign a confidentiality agreement saying that they will keep the information. It really only has 2 provisions. I mean, they're usually a couple pages long, but it really only has 2 important paragraphs. One is that you maintain the information confidential, you don't tell anybody. And 2 is you only use it for this purpose, no other purpose. That's really important. And you want to make sure that it covers just not your confidential, but customer confidential information as well. So that's that. And while I'm at it, you also have, sorry for skipping around, but as long as I'm doing it, the third piece of the puzzle in the covenants is non-solicitation, and that relates to employees, customers, suppliers, et cetera. And you want to make sure that they're not, if somebody leaves, they're not going to solicit your employees. Actually, we were just working on a letter today to 3 employees who went to work for the same place, and they had non-solicits, and it's hard to believe that they didn't solicit each other to get there. So, and so they were somehow the non-solicit got, I'm not sure who did it, but somebody must have done it. And so we're dealing with that issue. But you don't want people rating your company. So another one that's important to make sure we have. So we have non-compete, non-solicit, confidentiality, and the let me talk about IP for a second, because it's really important. The last piece of the employment agreement from this side that's important to have is invention assignment, and make sure that you own the IP that people create. Really important. And so when people create intellectual property for you, it's important that there be a clear, present assignment of the IP to the company. It is not funny to go try to get financing or sell the company and find that your employees or independent contractors didn't assign the IP to the company. As a general matter, one could rely, but they shouldn't, on work for hire by employees. There is no such concept for this. It's not applicable for independent contractors. So it's really important, just get the assignment of the IP. For example, in California, well, it's a long story, but the point is you should have current assignments of the IP and represent that they're not bringing in IP from a third party, and that and have a obligation after the employment arrangement to assign, to execute any and all documents necessary appropriate to assign it later. So they'll sign patent inventions and things like that. Okay. So once I own the IP, I got the confidentiality, the non-solicit, then I think, and non-compete, I think we're in pretty good shape. One of the other things you'll say, okay, well, that's all fine. How do I enforce this? And the agreement should say things like you're entitled to injunctive relief to stop people. Now that doesn't necessarily mean a court will enforce it, but it helps to have it. Sometimes you have a bit of a helper, because you say, okay, to the extent that they breach the agreement, it extends. The obligation extends for the period of time during which they breached. So that sort of extends, it creates a disincentive. Sometimes you have the fourth one here, which is you collect legal fees and costs. So not only is the person risking their own legal fees, but they may have to pay it to you. So that's another disincentive to breach it. Sometimes, and quite often, you have, if you've provided employee equity, which we'll talk about in a moment, you have a right to take back that employment, that employee equity. For nothing. And so that creates another incentive to comply, because if they don't comply afterwards, they go to a competitor, they lose that equity, which maybe they were looking forward to enjoying the benefit of. So that creates another disincentive, another tie. So what you're looking for is ways to create, you prefer not to enforce it. So you're trying to create incentives for people to comply. And these are some of them. Usually put in these agreements, where do you litigate? And you want to be clear as to where you're going to comply, where you're going to litigate, whether it's what state, and whether you're going to be in arbitration of the courts. And you want to be clear as to what governing law, although a governing law is going to apply. So that's that. Questions about those things? Did I answer the questions?
I just have a quick question about potential litigations and where they take place. Is it where the company has incorporated legally?
So on the, well, actually, I'll let, Mike, do you want to handle this one since you litigate?
Yeah,
I just draft. I draft, you litigate. So,
I mean, there are several different forms that could be used. The plaintiff is likely to sue where it's most convenient for the plaintiff. And so there will be a jurisdiction in that area. So for example, if the plaintiff, let's just say the plaintiff works in Ohio or lives in Ohio, and they sign the contract in Ohio, the court's going to take a look and say, okay, is there a tie to Ohio? And if there's a tie to Ohio, then Ohio law might apply. All right. And not only might Ohio law apply, but that's a proper venue, that's a proper forum for the case. But if there's no tie to Ohio, then they're going to probably look at where the company does business. And, you know, that could be where the principal place of business is. It could also be where the business was incorporated. But keep in mind that so long as there's some plausible reason, you can include a form selection clause in your contract, which says all disputes have to be held or heard in a certain forum. So for example, if you were incorporated in Delaware, you could choose Delaware as your forum. A lot of companies do that because they like the chancery courts in Delaware. The bottom line is that the plaintiff typically gets first choice. They have to have some tie to that jurisdiction. If they do, that's where the case is going to be heard. If they don't, then it reverts more or less back to where the company is based out of. But you can adjust those expectations with a contractual provision, which would allow you to litigate in a preferred form as opposed to the plaintiff's preferred form.
So Mike or David, do you have a preference where you steer startups? I mean, arbitration is typically less expensive to settle things than litigation.
Yeah, so I'm
urge startups to put arbitration in their contracts.
I'll give you my view, and then Mike will give you his. I want to litigate where I am, so I prefer Pennsylvania because that's where we are. So I won't have to travel to litigate, and it's easier. And B, I'm not a fan of arbitration as a general matter. That's just my preference. Because arbitration, because I can appeal a litigation and I can't appeal arbitration generally. And I for one, and again, I'm one, have had some bad experiences in arbitration where arbitrators are arbitrary. And so they come up with on the wrong side. I also don't, I mean, as far as expense goes, well, arguably court arbitration is less expensive. I find that's not always the case because you're also paying for the arbitrators and you're not paying for the judges. And so I prefer courts and in Pennsylvania if I can get away with it.
What he said.
Wow.
Thank you.
May I ask a question?
Yes.
Is there a difference in the appeal for binding or non-binding arbitration?
Yes. If it's non-binding arbitration, then presumably you can appeal it, but then I would ask the question of why bother? What's the point? I mean, that effectively becomes mediation, which is nothing wrong with. That's okay. But I want to, so that's okay. But I think my own view, if you're a startup, again, I'm worried about money and I want the most efficient way to do it. So I want to run to court, get my answer, and deal with it as fast as I can.
Yeah, but if you choose arbitration, it should be binding.
Correct.
Otherwise, It's a waste of time.
Yeah. Thank you. Yes. Yep. Other questions? There, and I will tell you, there's another school of thought on the arbitration side. They just happen to be wrong.
Hey, really quick. If an employee is laid off or fired, are they still bound to non-solicitation agreements or non-competes?
Yes, typically they are. If the agreement is reasonably well drafted, the agreement will say that regardless of the reason for the termination, the agreement is still enforceable, or these provisions are still in place. I will say that there are some courts out there, and these are particularly, this particularly occurs in cases where the equities might favor the worker. There are courts out there which say that that a factor to consider in whether to enforce the agreement is whether the employee left on their own or whether the employee was involuntarily separated. With the idea that if the employee was laid off, for example, for lack of work, that's really not his fault. You shouldn't be denying him the right to work. But again, that's only a factor that the court might consider. And really, it's the contractual language that the court's going to take a look at first.
Thanks.
Which goes to Don's point about it. That is the fact pattern that seems inequitable, and it goes to my first point about reading what you're signing, because it's a case where words do matter. It has an effect, and you hope people understand what they're getting into. Employee equity. There's and I'm not going to spend a lot of time on this, but I'll spend a little bit of time on it. Employee equity is an important part about giving people interest in making sure that the company succeeds. And this is a wonderful way to do it. And also, when you can't pay them a fortune, it's a nice way to give people some additional compensation without giving them cash. So it's a nice tool. Let me go through first the different kinds. I'll run through each one of these, but there's different kinds: restricted stock, options, profits, interest, and phantom equity plans. I'm going to run through these pretty fast, just so we have some sense of what they are, some of the benefits of each one of them, and then we'll talk about what you do's and don'ts. And I will say that, importantly, with each one of these, one of the common things is you want them to be vesting. It's really important. I mean, it's not funny to give somebody some stock options or some equity, have them quit the next day, and now they have all that stock. I mean, you want it to vest over time, and you can do it based upon time vesting. You can do it on performance vesting, but you want it to vest over a period of time. And you want to write to repurchase the stock back. Clearly for non-vested, that's pretty easy. The question is, do you buy back vested stock if they leave? And this is a little bit more of an issue, but it's one that one should at least think about, which is the concept is if an employee is with you, they should get the benefit of the increased value of the company while they're there with you. It's unclear that they should get the value after they leave. So arguably, you should be able to buy back their equity, whatever it is, stock or otherwise, for the period from the time they came in to the time they left. But after that, you want to be able to give that piece essentially of equity to somebody else. So sometimes we have a right to buy it back, not exercise it all the time, but buy it back if they leave.
So David, I'm so sorry.
No, okay.
Can you just give 2 sentences on what vesting is?
Sure. Vesting means that basically you have the right to receive the stock or the options if you're there for a period of time. So the best way to do is an example. If it vests over 4 years with 25% vesting, so you get 100 shares, 100 options, and it vests over 4 years, 25 options each year. That means that each year you're there, you get your 25 options. You get to keep your 25, it says your 25 options. So 25 the first year, 50, 25 the second year, making it 50, 25 the third year, 75, and finally fourth year, 100. And so if you leave, quit, or fired, you only have the number of options that have vested, which is that you've received by virtue of either time vesting, which means that you've stayed there, or performance vesting, which means you've hit certain milestones or based upon certain performance criteria.
Thank you.
Mm-hmm. The first kind of equity is restricted stock, and this is simply where, if you're a C corp or an LLC, you just give you the stock. Congratulations, you have X shares. And the thing about this is that's taxable. So if somebody gives you X number of shares of stock, then that's taxable immediately upon getting it. So that's not great, but it happens. But the good news is that typically in our situations, the company is not worth a whole lot at the beginning of the startup company. So we take the view it has a low value, and therefore getting that stock actually is not a big problem. Paying tax on it because it has relatively little value, so you don't pay much tax on it. So that's good.
David, could you speak to value in terms of can't value be determined by some predetermined formula when the stock agreement is initially set up, rather than I'm a startup, and as you go through different stages of fundraising, oftentimes there's different valuations set on the company. The value can be tied to a predetermined formula, or should it be tied to whatever the stated value is when you're trying to raise money from VCs?
Yeah, for this purpose, typically you want to, you can do it on agreed upon value. You can do that. The best way to do this is to get a 409A valuation. and get a third party to value the common stock, particularly if in a case where you're talking about like we have preferred stock or other capital raise events. Typically, the common stock is worth significantly less than the preferred stock. The question is how much is that discount and what the value is. And the best way to do it is to try to. There's 409A issues, which is a tax issue, but there's a quasi safe harbor that says that if you get an independent third-party valuation, then you're golden, if you will. And so in today's world, it's very common when you do either restricted stock options or any of these things to get a 409A valuation, which are relatively modestly priced at this point. If you're using CARTA, for example, which is the online registration for stock certificates and that kind of thing, you don't do paper stock certificates. They actually have a valuation process they go through, which is modest amount of money, and it gives you this very formal looking valuation. So my recommendation at this point is always just get a 409A valuation, a third party.
Excuse me, what is a modest cost? What's the range for CARTA? I've been told that lots of companies use CARTA, and I have a colleague who has done it. So I'm just curious.
I think it's a few $100s. So truly modest. Okay. I need to spend one moment on 83B elections, just to make sure we got it. Often when you get the restricted stock, it vests over a period of time. I just talked about vesting a little bit, but it vests over time. If you get stock which vests, so that to my example, you get 100 shares, it vests over 4 years, which means that after the first year, 25% vests, and then 25% vests, and 25% vests. Arguably, and tax-wise, each time it vests, you're supposed to pay tax on the stock at that vesting period. And arguably, it's increasing in value, and therefore you'd have to pay tax every year on that increased value. That would not be a good thing. But the IRS gives us a break and says instead of doing that, you can pay tax upon receipt on the entire amount. And of course, that's when the value of the company is relatively, is worth less. And therefore you can pay tax at that point rather than each year as the stock vests. Really important. In order to do that, you have to file what's called an 83B election, which has to be filed within 30 days after receipt of the stock. Let me repeat that. It has to be filed within 30 days after receipt of the stock. Not 31 days, not 32 days, within 30 days. If you miss that, there's no mother may I. So you got to do it. It's a huge benefit, but if you miss that deadline, it's not fun. So I always emphasize that point. Just if you think about restricted stock and you think about vesting, be sure and file an 83B election. It's easy to do, but it's just important to do. So what's the benefit of restricted stock? Well, you get capital gain treatment. If the company is ultimately sold, you own the stock, so you get capital gain treatment as opposed to ordinary income. As you know, ordinary income rates are higher than capital gains. Now, I'm not going to make any representation today as to what capital gains rates will be in the next couple of years, or ordinary income rates, but I suspect, and I don't even know what the difference between the two will ultimately be. But I can tell you that typically they're different. And usually ordinary income is higher than capital gains traditionally. So it's a benefit to get capital gains versus ordinary income. People who get, they are owners of stock immediately. You own the stock, so you vote, et cetera. So because of you pay tax originally, this is a good thing to do very early on if you want to give somebody equity while the value is low. Stock options are a right to acquire stock, and I better move. Stock options are a right to buy stock. Basically, it's a right to buy. If you have an option for a share of stock, you get a right to buy that share of stock at a set price, an option price or exercise price. So if the company is worth 20 cents a share, then you have a right to buy a share of stock if you pay 20 cents, and then you get that stock. The good news is that under our tax code, when you receive an option, that is not taxable. So that's good. And I should say one more thing. Options come in two flavors, non-qualified and qualified. I'll talk about qualified in a moment, but typically what you give for particularly startups is non-qualified stock options. And no stock options, you get paid taxed when you receive it. There's the option. When you exercise the stock option, you pay tax on the amount, the difference between the fair market value on the date of exercise and the strike price. Right, and that's at ordinary income rates. And then if you hold it for more than a year after you exercise, there's capital gain on that difference between the sale price and the exercise price, or the fair market value at the time of the exercise. So you don't own stock until you exercise, so you don't vote, but you have a right to buy stock along the way. So the nice thing about options is it's non-taxable when you get it. And so that's a benefit. So if you get later on in the company and you want to give people some equity, but you don't want to pay tax when they get it, options is a lovely way to do it. Those are non-qualified options. Qualified options are, and I'm not going to spend a lot of time on this, but they are tax beneficial options. And they also, you don't get paid tax on receipt, but you also don't pay tax when you exercise. And you only pay tax when you sell the stock, and it's a capital gains rate. So that's a very attractive alternative. But there's there's lots of restrictions in order to qualify for qualified options. And it has to be only C corporations. Option price has to be at fair market value. The most important one is that you have to hold the stock for at least a year after you exercise. And most of the time in the startup world, you only exercise the options at the time that of the exit. So much of the time, I shouldn't say all the time, but much of the time that's the case, and that makes it end up being qualified options, not non-qualified for the qualified options. There's some other requirements, but that's the principal one. That's a bit of an issue. And lastly, only in limited liability companies and partnerships, there's something called profits interests. And these are sort of interesting, which is that's the right for employees or people, holders of profits interests, to enjoy the benefit of the appreciation of value from the time they come in to the time they leave. So if you get a profits interest and you come in when the company's worth $1 million, you'll get a membership interest that will give you the appreciation of value from that $1 million above. It's an ownership interest, and so but it's a profits interest. Again, no tax upon issuance, which is good. You're a member when you get it. It can be not voting or non-voting, depending on what you agree on. There's a little bit of a kink here, because if you hold an interest in an LLC, you actually can't get a W-2. You're actually a K-1, which gets a little complicated. And most importantly, profits interests are amazingly confusing. People don't understand them. You can explain them all day long, and they're just confusing. They're not. People understand options. They understand owning stock. Profits interests are a little confusing. Let me just run through quick example of sort of the difference in the value for people, just to give some sense of it. Let's assume for the moment that a company is worth $500,000, and we sell it later for $5 million, and we give an employee 1%. And let's assume those rates that are on the screen there. I'm going to run through these, and then there'll be a slide showing the comparison. The restricted stock, I talked about, you pay tax on it when you get it. So I said that you get 1%, it was worth $500,000. So even I could do that. That means that it was worth $5,000. You pay tax on that $5,000 of $1,600. Later, when we sell the company, you got $50,000 less the $5,000 you paid, capital gain rate, $9,000. So it ended up costing you ended up benefited by $39,400. And that was because you got capital gain treatment on it, the difference between the sale price and the amount you paid. Non-qualified options, as I mentioned, you don't pay tax when you got it. You have to exercise. So the exercise price would be $5,000 because that was the fair market value. You pay tax when you exercise at the ordinary income rate. So you end up walking away with $30,600. Same set of facts, but you ended up walking away with $30,600. Less attractive. I'll compare them when we get to it. Where's my profits interest? Not qualified. Profits interest. Again, no tax on receipt. You get the value, the benefit of the value from the time you came in when it was worth $500,000. The time you left, it was $5 million, 1%. That's $45,000. And you pay tax capital gain, $36,000. So how'd that all compare? Restricted stock, best of the bunch, you end up with close to $40,000. Non-qualified options, $30,000, $30,600. So it's actually, it's 25% less roughly, and profits interest somewhere in between. So my only point here is that it is important. The tax consequences are important when you think about which of these to use.
So David, on
Yep.
those examples, did they file 83B?
You would
exemptions?
file the 83B on the restricted stock only, not on options.
Okay.
Yeah. That's not true. I lied. Profits interest, you file an 83B too. Sorry. Restricted stock and profits interest, you file an 83B. Obviously restricted stock for the employee side is best from when it's a low value. Profits interests are attractive only if you're an LLC, but again, they can be confusing. Non-qualified options are attractive alternative. You are giving people upside. They don't pay tax when they get it, and so that's kind of good. And don't forget about the 83B election, which I already emphasized. Somebody asked earlier about equity for interns, my view of employee equity is that it shouldn't be given away willy-nilly. It should be carefully thought out. Options equity should only be given out. The purpose is only to attract and maintain talent. That's the purpose. And so if you don't need to do it, don't do it because you only got 100% of the company, and having a bunch of people with equity who aren't really contributing at that point or didn't require it is not helpful to the cause. So I'm sort of cheap about equity, I'll tell you that. But I think that I'm not sure that you need to give equity to an intern to incent them to perform. And to get for them to have the right experience. So I guess I would be kind of resistant to be giving interns equity. That's me. Typically people always ask me, well, how much equity should go into the pool? And generally, you see 10 to 15% employee option just in startups. It varies. I mean, it can be higher, it can be lower. Generally, what you want to do is look and see, okay, how much do I need to track? What's the employee pool going to look like? How much do I think I need for that? And then sort of look at it that way. And it can be replenished over time. So if you use up the whole pool, you can issue some more. Be careful in not making the pool too big too early, because when you go to get venture capital, if that's what you're going to do, they're going to look at that and they'll take that in the account instead of the valuation, sort of the pre-money valuation. They'll count that entire pool, and so you'll end up with having a little less of the company. So the only point there is to bear in mind when you're creating the option pool, if you're going to raise equity, think about that size of that pool as it'll be envisioned by the venture capitalist when they come in. Let's see what else I have on this, and that's it on the employee equity. I guess I've come around over time to simplicity is my friend, and I find people find options to be the most familiar, and so I've sort of have found them to be the easiest to deal with. So that's why I'm sort of high on options. Questions?